Hello, everybody. I am LCodina with Realty in Houston Group with Keller Williams, and I am here today with a wonderful partner, Jeffrey Novy, who is an attorney, and he is going to ask questions regarding probate and wills and everything that's related to real estate in that area. So Jeffrey, thank you so very much for meeting with me today and doing this very informational video regarding probate and wills and the sort. So why don't you tell us a little bit about you while I pull up the slides.
Thank you. First of all, thank you for having me. You can call me Jeff. I haven't heard Jeffrey in a long time. Usually it's when I got in trouble with my mother years ago, but you can call me Jeff. I've been practicing law for almost 47 years. Most of that time has been in the probate, wills, guardianship arena and probate. So with some of my experience and what I know to be the law, I thought that this would be a good situation to explain some things to people, potential clients for you, possibly for me. I would say that if anybody has questions regarding anything that I'm talking about today, that I would definitely try to talk with an attorney who has experience in these areas to confirm what I'm saying. And not only that, each case has a different set of fact situations, and that fact situation needs to be analyzed by an attorney to be able to help somebody through preparation of documents or to go through a probate process or an alternative process if and when somebody has passed away.
And we understand that everything that you're going to be speaking today regarding this is going to be in a general manner only and not related to anything in particular, because we are not going to be discussing any cases at all. So just to go over really quick what we are going to be encompassing today, it will be what is a will, defining what probate is, and then you will explain to us what all these words mean. What is an independent executor, a guardian, and a trustee, and how they differ from each other. And then what would happen if there is no will, which it's very common from what I hear. And then also, if there is no will, what can somebody do at that point? So let's go ahead and jump to the first question what is a will?
My definition of what a will is, it's a legal document that expresses your wishes as to what you want to have done or distribution of your property after you've passed away. We can get into real technical definitions and go to a dictionary, go to Google, but to me, that's what a good definition of a will is. There's a lot that goes into it, different provisions. Basically, I think that should cover it. It's just your ability to put in writing what you want to have done with whatever you have after you pass away.
Wonderful. And one quick question that a lot of us have, we're not attorneys. Can somebody do a will themselves, or does it need to be done with an attorney in order for it to be valid? Or do you need a witness, or can you just write something and then go notarize it?
That's a good question. There are all different types of wills that can and usually are recognized if it goes through the probate process, which I'll explain in just a little while. You can have a holographic will. That means it's totally in your handwriting and you can sign it. You could have it witnessed if you want to. You have it witnessed and notarized if you want to. But it has got to be solely in that person's handwriting who is making that will for himself or herself. You can also go online. There are different companies that are offering wills online. You can go to certain companies and get a pre-printed form, or go get software to have a will prepared. I would still have it reviewed by an attorney, only because a person doesn't know enough to ask a question of the software or of the form. And sometimes people change a line, change a statement. They don't like what they see in there, and they can cause more problems than they had before they even didn't have the will. I mean, I would still have an attorney just to review it, just to make sure, because a lot of these wills are not tailored for Texas law. And therefore, there's more work that has to be done if it goes through the probate process. And usually that cost is a lot more than if a person had had an attorney maybe just draft that will in the first place. So the general answer is yes, I still would have somebody review that will.
Thank you. So let's go to the next question, which is defining probate. So exactly what is probate, Jeff?
Well, technically, the probate really has to do with being able to have an original will in front of a judge, and the person who's testifying actually testifies as to the facts of that will, that it was written by the person who passed away, or signed by it was signed by that person and it passed away. But the probate really is the whole process from the beginning to the end. And that means, usually seeing an attorney gets information and prepares an application to probate that will. Since about 5-6 years ago, we electronically file all documents. But in the case where there's will and it's being probated, you have to essentially have the original will filed with the county clerk's office in which that person resided. You never, if you go through that process, you never get the original will back, but it's there forever. And you can, of course, if you want to, you can always get a certified copy of that will. But the probate process is, getting that document filed, preparing the documents necessary so that you can have a hearing and hopefully have a personal representative appointed so that assets can be obtained, transferred, sold, or distributed, pay taxes. If there's property, there needs to be a deed that usually gets filed. You have to file an inventory, appraisement, and list of claims. There are all kinds of things that an attorney does to make sure that the requirements of the Texas Estates Code is followed strictly.
Yeah. Now asking a question regarding time. Let's say, and this is assuming everything is perfect, it was a great will, it was done with an attorney, it was filed, whatever had to be filed. How long is the probate process would take in average? I'm sure there is exceptions, but in average, when everything is in its place the way it should be, how long will it take for this process from beginning to end?
Well, I can tell you pre-pandemic situation.
Perfect.
With the pandemic, it's each county, it's taking different amounts of time. We are now having probate hearings online with Zoom, so that there does not have to be an in-person testimonial or testifying situation for witnesses. That's the easiest part. The problem is, whereas we used to file all these documents, hard copies, at the time we would be at the courthouse, now all these things are taking more time to get done because we have to electronically file it, make requests for copies or documents or letters testamentary. I'll have to go into that term later. And, some of these counties are half, they're working half staff, they're working every other day. The mail is taking a lot longer. It's really hard to say. And depending on which county you're in, sometimes it takes a month or 2 months to get a hearing date. It's awfully hard to give a generalization because each county is taking different amounts of time to get things done.
But before probate, how long was it?
Oh, with a simple estate and maybe just one piece of property or a couple of bank accounts, I mean, you could probably get it done maybe without going into specifics and without having different facts for different cases, I would say maybe 3 months, something like that. Maybe sooner. Just depends.
So it's not
Um,
years. It's not a process. When everybody hears probate, and they go, "Oh my gosh, no way! That's gonna take forever. Will be next year, 2 years." No, if everything is in place, if you had an attorney, if it's a simple, somebody who had just a property and a few bank accounts, like you said, and they will be about 3 months. So let's say between 3 and 6 months, it's a
yeah,
good.
I would say that's about right. I mean, yeah, there's some cases where there are contests and all kinds of things, or the personal representative didn't do something they were supposed to do. And so, when you hear somebody say, oh, well, this has been in probate for 3 years, well, there's something that's gone wrong there. And it's, not a simple situation. So, but yeah, I would say 3 to 6 months.
If somebody doesn't have a will, is it also called probate?
Yes. Yes. If you go through a legal process um, to have, uh, well, if somebody dies without a will, we're maybe jumping the gun a little bit here, but you have to prove up in some type of a format or legal process who are the only heirs of the person who passed away.
But it's still called probate. That was just my question.
It's still part, yeah. Airship is still part of the probate process. Yes.
And then what is the difference between probate and non-probate assets, and where would real estate fall between these two?
I'm sorry, what was your last part of the question?
Real estate, where does it
Oh,
fall?
real estate. Okay. The best way to explain about what probate assets are is to explain what aren't or what is not.
Okay.
A probate asset is something that would have to go through a will to be taken care of for ultimate distribution to who the beneficiaries are in the will. But non-probate assets go outside of the will. For instance, if you have a life insurance policy, you have a beneficiary designation. It goes outside the will, generally speaking. If you have an IRA that has a beneficiary designation, goes outside the purview of the will. If you have a 401k, again, it goes outside of the probate process and doesn't go through the will. If you have some of the following bank accounts set up with what we call POD, or pay on death on an account, or transfer on death, you are able to name a beneficiary so that after somebody passes away, that person gets those funds. Or if you have an account, say it's a husband and wife, you both have signed the documents when you first came into a bank and you didn't realize what you were signing, but many times they set those accounts up as joint tenant with right of survivorship, JTWROS. And in that situation, if one person passes away, you can take a death certificate, go to the bank, and they will pay over to that person who's also listed on that account. So those are some examples of things that don't go through the will not go through the probate process.
That's not probate.
So then people say, well, gee whiz, why do I need a will? Well, first of all, you probably need a will in case there's a problem with any of those prior things that we talked about. Sometimes people forget to put a beneficiary, or they put a beneficiary and that person predeceases the person. Or sometimes they say the beneficiary, they write down estate, So you still need to have that just in case. It's like a safety net situation. So I see we have maybe some definitions here to talk about next.
Yes. So regarding the probate and the wills and all of that, I know that when I'm looking at these things regarding real estate, there is a difference. There's on whether it's an independent executor or guardian, somebody's a trustee. Is there a difference between all of this? For example, independent executors, or can you have all three in one probate process, or do you have to have just one of the three? What exactly are independent executors?
Well, the independent executor is the name of a personal representative that you have in your will. That person gathers the assets of the estate, pays debts, applies illness, cost to administer the estate, taxes if any are due, and then they're supposed to distribute the estate according to what the will says. They are free of court control. That is the most important thing about having a will, being able to appoint an independent executor. In a will, you can, if you have minor children underneath the age of 18, you have the ability to name, this is one document that you can name a person to physically take care of any minor child under the age of 18. And you also have the ability to appoint a guardian of the estate. So if that child has assets, that you have the ability to appoint a guardian of the person and estate for each child. Cannot be two people, can't be a husband and wife, it can only be one person. So if an attorney has a will to prepare and their minor children, we're going to ask that question: who would you want to take care of your child, and who would you want to take care of any asset that this child has? If there are children under the age of 18, lawyers also suggest that maybe you allow that lawyer to prepare a trust in the will. That trust would only spring to life in the event that both parents are deceased and there's a minor child underneath the age of 18, so that a trustee can manage and take care of that child's financial needs. The guardian and the trustee can be the same person if they need to be, or if you want, or somebody wants it to be. So, and without going into detail, because we can put all kinds of things in a trust that are in a will, and that is really called a testamentary trust. It only springs to life through the will if any children underneath the age of 18 and both biological parents are deceased.
Got it. So you could have all three actually working during one of these probate processes. One, the independent executor is the one who's going to make sure that everything else gets done. And then the guardian and the trustee could actually be the same person, you said, but
Yep.
it could also be three different people working on one, how'd you call it, in one document, on one file, completely separate.
Yeah, what estate, yeah.
One,
Yeah.
thank you.
Of course, a lot of times when people are married, they appoint their spouse as the independent executor. But we also ask for alternates for all three of these positions, because one never knows what's going to happen in the future.
Got it. So it's best to just appoint one of each, get it out of the way during the will, at the time of the will.
Well, yeah, the facts warrant, yes, yeah.
So what happens if there is no will?
Problems.
Chaos is what I'm imagining.
Yeah, more problems than people would want to have under the circumstance.
Yes.
A lot of that depends on the nature of the assets of the estate. I'm going to throw out a few situations or alternatives if somebody dies without a will. It depends. If it's usually within 4 years of the date the person passes away, you can file an application to determine heirship or to declare heirship. Then you go back to the Texas Estates Code to see who are the heirs based upon who is still living after that person died. So you can have that sometimes just the heirship determination through a court situation is enough. You get a court order to declare who the heirs are. Sometimes you have to go a step beyond that because you need to have somebody in charge to be able to handle the assets of the estate. So you ask that an independent administrator be appointed. All the heirs have to agree. Lawyers hope that there can be an independent administration, free of court control. But if the heirs don't get along, then you end up having what's called a dependent administration. Much more expensive, time-consuming, because the judge will then have control over the assets, control over what's sold and what's to be paid, and you have to have an accounting every year until you distribute everything. So we're all hoping that it doesn't have to go to that route. So you've got an heirship. Sometimes you have an heirship with an administration. Other possibilities are that depending on the size and the type of assets. Sometimes you can go to court. There's a form that you can fill out with the county clerk's office, or a small states affidavit. That does go to a judge. It's looked at by a staff lawyer or an auditor, depending on what county you're in. The assets, I believe, cannot exceed $100,000. Also, the debts cannot exceed the value of the estate in order for this to go through. So,
is what you're talking about?
Yes, the small states affidavit, yes.
So we'll talk about this one really quick. So if there is no will, but there is something that you mentioned, revocable transfer on death deed.
Right. This is a mechanism to use. It's coming to being, I should know, but it's probably within the last 10 years, maybe a little longer in the legal arena. A lot of times people were married and a husband passed away, for example. The only asset that they had was their house. So in order to prevent that surviving spouse to go through the whole legal process just to transfer title to that property, there's a legal format document called a revocable transfer on death deed. It is used, it is a real deed, and in that document, I'm just paraphrasing and boiling everything down. You have a right to say, hey, if I pass away, I want my house with the legal description to go to so-and-so. And if so-and-so doesn't survive me, then it goes to somebody else. That deed is recorded while the person is alive. If a person passes away, then a title company will pick up that document, and all that will have to be shown to them also would be a death certificate. And that's enough to be able to transfer title to that property. But that has to be done, and it has to be recorded while the person is alive.
While the person is alive. It sounds to me like it's a great, option if somebody thinks, okay, this is all I have, and I know everybody's going to fight about this house, and I know what mass is going to be. Let's at least this. Let me make sure that I leave it to my spouse, my kid, or whoever it is, and this will no longer be an item that will be discussed. It will be completely left out of probate. Is that correct?
That's correct, and that's assuming that all the facts line up and everything is okay. Yes.
Right. And then you were talking about something about if there is no will, the person has passed, and then you were talking about small states of affidavit.
Yeah, and I just was talking about that previously to speaking about the revocable transfer on death deed. Yeah, this small states affidavit is a form that you can get online on hard copy from the county clerk's office in which you reside. But it's used to help transfer real estate and personal property. But again, the assets cannot exceed $100,000, and the debts cannot exceed the value of the estate. So if you got a $20,000 estate and you got $30,000 worth of debt, you can't use this document.
Got it.
Again, I talked about the Airship Determination. This is a means to go to court to determine who the legal heirs are, and a judge will sign an order usually after that's taken care of, and that can be used to present evidence that these are the only people who are to receive whatever assets that there are. Usually, this is usually used with real estate.
Got it.
Then again, you could go a step further or farther to have the heirs determined and couple it with an administration, and hopefully it's independent. And again, like I spoke before, that the heirs can all agree, hopefully, that that one person can be the person representative of the estate. And if not, then if you have heirs that got problems with each other, don't trust each other, then you have a situation that will require much more work and court control over what's going on, among other things. Sometimes, depending on the facts and circumstances, an attorney or somebody can prepare an affidavit of heirship. That's essentially a family history of the person who's died, shows all the marriages, if the person was married or single at the time they passed away, and all their children. from whatever relationships, marriage or not. And that document can be recorded in the county clerk's office in real property records. And usually it's used if somebody has passed away and it's been several years and their will was never probated, or to show a situation where there's a gap in between title. You know, what happened between this marriage and that marriage, or whatever. And that document has to have two witnesses who will attest and sign and corroborate all the facts that were listed by the person who is signing this document. And then again, that gets recorded in the real property records in the county in which the property is located. This is only usually used for real estate purposes.
Oh, again, okay. So the affidavit of heirship is only used, and same thing for heirship determination. Airship. Sorry, excuse my heavy accent there. Well, okay. I believe that is all that I had for major questions for you, Jeff. And what I see now at the end is what I see almost with every single video, with every single professional that I interview, is it all boils down to talk to you, right? Talk to a professional. This just emphasizes all the huge differences of options for anybody who is in this situation, and how important it is to talk to somebody like you. So if somebody saw this video and they're like, okay, one of these could apply for me, I want more information, what is the best way to get a hold of you, Jeff? Is it by email, in your phone number, is that correct?
Give me a call. I usually answer my own phone. Scares the heck out of a lot of people, but I've tried to pare down my overhead and do my own work. Don't hide behind a secretary or a paralegal. But whether it's me or somebody else, if you have questions, I think it's very prudent to talk to an attorney first. If somebody wants to call me, that's great, or you can email me also. And I thank you for the opportunity to give some of my advice and my opinions as to the topic that we talked about today.
Thank you so very much, Jeff. I really appreciate you taking the time to allow me to ask you all these questions that everybody's asking regarding real estate. So, all right, guys, thank you for watching this video. I am LCodina with Realty in Houston's with Realty in Houston's group with Keller Williams. I am here to answer all your questions about real estate. Give me a call at 281-723-0068 and ask me about Realty in Houston. Thanks again, Jeff. We'll talk to you soon.
Thank you.
Bye-bye.
I appreciate it.